and other minorities. On the slide you may see the pictures showing how Ukraine demolished the houses of Crimean Tatars in Crimea and how Ukrainian law enforcement authorities treated the inhabitants. The fourth report of the European Commission against Racism and Intolerance in 2012 described that anti-Tatar sentiment remains an issue in Ukraine and appears to have increased in recent years, and noted that local politicians' tendency to ignore or deny the specific problems faced by Crimean Tatars. As we showed in the rejoinder, in 2013, the OSCE explained that there were numerous impediments for studying Crimean Tatar language in Ukraine, including lack of legal guarantees, lack of financing, lack of qualified teachers, and non-availability of textbooks. Ukrainian representatives like to discuss the deportation of Crimean Tatars in 1944 during the World War II in this courtroom, as if this event has anything to do with this case. However, what Ukraine fails to mention is the fact that it was Russia, not Ukraine, that took specific legal and practical measures to rehabilitate all ethnic minorities that had suffered from deportation, including the Crimean Tatars. Actually, the demand to adopt these measures was pursued by Crimean Tatars for years with Ukrainian authorities to no avail. See, for example, the quote from the member of Ukraine's delegation, Chubarov, back in 2013. In April 2014, President Putin declared the following: "We certainly need to do everything we can to rehabilitate and restore the legitimate rights and interests of Crimean Tatar people at a time when Crimea is joining Russia. That is why my colleagues in the government and the Presidential Executive Office and I are now preparing an executive order on the rehabilitation of Crimean Tatars." The rehabilitation order was adopted. In accordance with this decree, budgetary allocations were made under state financing programs from 2014 to 2021. The Crimean budget received over $11 billion. By 2025, the sum will exceed $20 billion. Russia has drastically improved the living conditions in areas of the peninsula predominantly inhabited by Crimean Tatars. You can see on the screen some of the results. Russia built and improved schools and kindergartens for Ukrainians and Crimean Tatars, published literature on history and culture of various peoples of Crimea, including Crimean Tatars and Ukrainians. Only the Gasprinsky Media Center published 200 such books. The Cathedral Mosque in Simferopol, which construction is planned to be completed this year, will be one of the largest mosques in Russia. It is not surprising that recently Council of Crimean Tatars issued a statement declaring the following: "The reunification of Crimea and Russia has brought much good. Crimean Tatars, along with other Crimeans, obtained an opportunity to revive, keep up and develop their own language, history and culture, broadcast the national and cultural originality of the Crimean Tatar people. The Crimean Tatar language is recognized as one of the state languages of the Republic of Crimea. Socially important literature is published in Crimean Tatar. Crimean Tatar mass media are active in their business. We are privileged to have among us, among our delegation today, Crimean Tatars. Mr. Bairov, the Deputy Mufti of Crimea, Mr. Shirin, member of the Public Chamber of Crimea, and Ms. Shirina, Professor of Crimea Federal University." All of the above confirms that Ukraine's case on the third consists of manifestly unfounded accusations and cannot be seriously upheld. Ukraine seeks to rely on reports of the OHCHR that cannot be seen as compelling evidence in this case for the reasons that court already knows. There is also no merit in Ukraine's references to the Third Committee's concluding observations on the most recent report of the Russian Federation. Russia specifically notified the committee that it was premature to engage in dialogue on these issues as they were pending before this court. There was no dialogue with the Russian Federation on these issues as required by the procedure of the committee. Thus, the conclusions of the committee are no more than allegations. Madam President, distinguished members of the court, on Tuesday, a representative of Ukraine stated that in modern era there are few laws that simply state racist purpose or mandate a racist effect. However, a vivid example is on the surface. Ukraine passes such laws and decrees prohibiting Russian language and culture and glorifying Nazi collaborators. Russia has repeatedly informed the international community about the ongoing oppression of the Russian population in Ukraine. While Ukraine is having issues with access to education in native languages in Crimea, which are fully available, in effect prohibits education in Russian after the 4th grade, i.e. elementary school. By October 2018, Ukraine banned more than 780 Russian films and TV shows. In 2019, Ukraine restricted publication of scientific materials in Russian language, while permitting publishing them in English and EU languages. Restricted publication of printed media in Russian language. Ukraine also destroyed monuments of prominent Russian writers, such as Alexander Pushkin and Maxim Gorky. While Ukraine has issues with the prohibition of Majlis that was involved in blowing up of electricity pylons in Crimea, Ukraine's president introduced to the parliament of Ukraine a bill on the total ban of the Ukrainian Orthodox Church, on the ground that it has connections with Russian Orthodoxy. A canonical church with millions of parishioners is to be banned and all its property confiscated. Representatives of Ukraine insist that Russia's reference to the Nazi roots of the Maidan authorities in Kiev are just propaganda. We suggest that the court make its own conclusion. In its rejoinder, Russia demonstrated how Nazism took ground in Ukraine during the World War II. Over the years of independence of Ukraine, about 15 neo-Nazi parties and groups have emerged. You can see on the slide what government positions were taken after Maidan coup d'etat by representatives of the neo-Nazi Svoboda party. Those are actually key ministries. Nazi collaborators are considered national heroes in today's Ukraine. Decades after their heinous crimes, presidential decrees were adopted, awarding both Nazi collaborators Stepan Bandera and Roman Shukhevich the title of Hero of Ukraine, the highest degree of distinction. More than 200 streets across Ukraine are called after Nazi collaborators. In Kiev, Moscow Avenue was renamed after Stepan Bandera, the chief Nazi henchman. In addition, his birthday on the 1st January is officially celebrated across the country in accordance with the decision of the parliament. Vatutin Avenue, named after Soviet military commander who was killed by the Nazi collaborators while liberating Ukraine from Nazis, was renamed after Wehrmacht Hauptsturmführer Roman Shukhevich. The Nazi collaborators are firmly rooted in the pages of Ukrainian school textbooks. See the following examples. In addition, the Ukrainian Ministry of Education, with the support of nationalist organizations, annually holds so-called youth military patriotic games. Many young neo-Nazis grown on such war games later joined the neo-Nazi battalions and went on to kill civilians in Donbass. While Ukraine on Tuesday said that it came to protect Ukrainian people in this court, their high-level officials openly stated the following. On 19th of May this year, Mr. Budanov, the head of Ukraine's main military intelligence agency, when asked about Crimeans, told, "They are not just very disloyal people. They are people with changed mentality, not even through an ideology. This is psyche. We have to re-educate those who we can re-educate either with a carrot or with a stick." Mr. Podolyak, advisor to the head of the Ukrainian presidential administration, made the following statement. You want to speak Russian, you want to read Dostoevsky or Yesenin, or you want to watch Russian films. This is not about Crimea. This is not about how one should live on the territory of the state called Ukraine. We should completely close everything that concerns Russian cultural space. There should be only Ukrainian cultural space or global cultural space. There should be no Russianness there. And we should not have a dialogue whether a person has the right to use Russian language or not. Use it at home. Thus, Ukraine's claim must be rejected not only because they are groundless, but also by virtue of the clean hands doctrine. Madam President, that concludes my presentation. May I respectfully ask you to give the floor to Mr. Chikaya, who will address the scope of the cert and of the claims brought by Ukraine.
I thank the agent of the Russian Federation, and I now give the floor to Mr. Jean-Charles Chikaya. You have the floor, sir.
Merci, Madame la...
Thank you, Madam President. Madam President, members of the Court, it is an honor for me to appear before you and to do it on behalf of the Russian Federation. As has been recalled by our agent, it is for me today to take a look at the scope of the dispute as presented by Ukraine and the definition of racial discrimination in the context of the International Convention on the Elimination of All Forms of Racial Discrimination. There are 5 key issues that must be examined in this respect. First of all, the limited scope of Ukraine's application. As the agent has recalled, Ukraine wants you to decide that the Russian Federation has embarked upon a campaign of systematic racial discrimination, targeting Tatar and Ukrainian communities in Crimea. But Ukraine cannot depart from the limits defined by your 2019 judgment on the preliminary objections. Secondly, I will take a look at the criteria that have to apply in order to determine the existence of the so-called discrimination campaign. Then I will show the attempt by Ukraine to reformulate its initial application, turning it into a complaint concerning indirect discrimination. And as I will explain, this is not compatible with the statement according to which Russia carried out a systematic campaign of racial discrimination, which by definition is a deliberate and planned act. What is more, indirect discrimination, as defined by Ukraine, in any case, is not governed as such by the Convention. In the 4th part of my oral arguments, I will take a look at the attempt by Ukraine to broaden the scope of the Convention by referring to political opinions, saying that they're covered by the definition of ethnicity. Now, this approach is clearly contrary to the Convention and to your jurisprudence, and it reveals that the true objective pursued by Ukraine, as the agent has just pointed out, in this case, is to challenge the very status of Crimea. Lastly, I will show that the measures adopted on justiciable grounds are not a racial discrimination within the meaning of the Convention. Ukraine has come before you with an extremely serious accusation. It is saying that Russia deliberately embarked upon a systematic campaign of racial discrimination targeting the Tatar and Ukrainian communities in Crimea. The agent for Ukraine declared that Russia, and I quote, embarked upon a campaign of cultural erasure targeting ethnic Ukrainians and the Tatars of Crimea. We must pause here in order to recall historic examples of campaigns, systematic campaigns of racial discrimination, which, as the court knows full well, are, if you take the best known of them, the Nazi regime in Germany, the apartheid regime in South Africa. As regards the struggles of these regimes, and the agent has pointed out, Russia, the Soviet Union, played its role, and of course I speak as an African, but not only I, everybody else is aware of what was involved. So Ukraine is seeking to assimilate the situation in Crimea to these odious criminal regimes. So, this artificial submission before you is in stark contrast with the precedents that I have just cited. The way in which Ukraine has chosen to formulate its application has a significant impact on the scope of the dispute before you. It's precisely because of Ukraine's allegation that there was a systematic campaign of racial discrimination that the court, in its 2019 judgment, dismissed Russia's objection of inadmissibility on the grounds that internal remedies had not been exhausted. And I quote, and you have it before you so that it is perfectly clear, according to Ukraine, the Russian Federation has engaged in a sustained campaign of racial discrimination carried out through acts repeated over an appreciable period of time, starting in 2014, against the Crimean Tatar and Ukrainian communities in Crimea. Ukraine does not adopt the cause of one or more of its nationals, but challenges, on the basis of CERD, the alleged pattern of conduct of the Russian Federation with regard to the treatment of the Crimean, Tatar, and Ukrainian communities in Crimea. The court's jurisdiction is limited to deciding whether it is so that a systematic campaign of racial discrimination targeting the Tatar and Ukrainian communities in Crimea was established by the Russian Federation. As I shall be demonstrating, and this will be done also subsequently by Professor Azeri, the answer is clearly in the negative. The court's jurisprudence clearly indicates that the claims against the state involving charges, and this has been recalled just now, of exceptional gravity must be proved by evidence that is fully conclusive, and that a charge of exceptional gravity against a state requires a high degree of certainty adapted to the level of gravity. This rule governs administration of evidence and must apply to this case. Ms. Cheek's comments in this regard are, at the least, most surprising. She was speaking on behalf of Ukraine, and she suggested that the court might apply a low standard of proof, because even if Ukraine's allegations, according to her, are without doubt serious in nature, they don't involve the same types of violations as in the case of genocide in Bosnia. Now, this is incorrect. Admittedly, this case does not concern genocide, but a systematic campaign of racial discrimination is, however, an accusation that is just as extraordinarily serious. Mr. Coe spent some time talking about the ban on racial discrimination as a rule of jus cogens and the way in which Russia allegedly systematically violated that standard. Now, how can one seriously make such an assertion and not draw the conclusions thereof in terms of evidence? It is clear that systematic violation of a rule of jus cogens is not something that can be proved lightly. The court must refrain from sending any such message to states. Realizing, subsequently, that there is no real evidence of a systematic campaign of racial discrimination, Ukraine focuses on isolated and unrelated allegations without any relation to racial discrimination, while passing over problems of substance and methodology attached to such an approach. It even tries to transform the dispute into a case of indirect discrimination. All of that is not only in contradiction with your ruling of 2019, but it also proves the artificial nature of an alleged systematic campaign of racial discrimination, which has never existed in the multi-ethnic country, which is what Russia is. Madam President, I would now like to turn to the criteria required in order to establish the existence of what Ukraine qualifies as a systematic campaign of racial discrimination. As demonstrated by the Russian Federation in its written submissions, the following cumulative criteria have to be met. First of all, the alleged acts have to be ascribable to the Russian Federation. Secondly, the alleged acts have each to constitute a violation of the Convention, in other words, a distinction, exclusion, restriction, or preference based on race or ethnic origin within the meaning of the Convention, whose purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise of on an equal footing of human rights and fundamental freedoms, and has no objective or reasonable justification. Thirdly, the alleged acts must be part and parcel of a systematic campaign or policy. This latter point is particularly important in this case. Ukraine must demonstrate in this regard that the alleged acts of racial discrimination are sufficiently interconnected in the context of a general policy, that the Russian Federation had the intention to target specifically the Tatar and Ukrainian communities, and that the alleged systematic campaign had a disproportionate effect on those communities as compared to other ethnic groups. At the outset, it should be underscored that those criteria are not something that's been cooked up by Russia, as insinuated Tuesday by one of Ukraine's counsel, but based on the convention, the way in which Ukraine formulated its application, the judgment of 2019 of the court, and other relevant sources of international law that you will find in further detail in the Crown Memorial and the rejoinder of the Russian Federation. It goes without saying that as regards the systematic campaign of racial discrimination, Ukraine must demonstrate the systematic nature of the alleged behavior of Russia. At the very least, Ukraine must demonstrate a series of facts that occurred several times over, committed in a deliberate and organized fashion in order to reach a specific goal. In other words, there have to be identical or analogous violations of the Convention that are sufficiently interconnected and committed in a planned and intentional manner with the purpose of singling out the Crimean Tatars and Ukrainians. Without any such proof, it would quite simply be impossible to speak in terms of a systematic campaign. Ukraine asserts that it would be enough to demonstrate a multitude of individual violations of the Convention by Russia, and that an inference can be drawn from such alleged violations to reach a cumulative result, along with the conclusion that a systematic campaign exists. Ms. Cheek added that the comprehensive nature of Russia's asserted violations leads to the inevitable conclusion that Russia has engaged in a campaign of racial discrimination. This assertion shows once again that Ukraine is refusing to demonstrate that there really was a systematic campaign as opposed to separate unrelated cases. This is extremely revealing of the truth. Ukraine has formulated its request artificially with the obvious aim of circumventing the requirement to exhaust domestic remedies, internal remedies. What is more, Ukraine has to demonstrate that the Russian Federation had a specific intention, which was to target the Tatar and Ukrainian communities. Such an intention to discriminate on the basis of ethnicity is an inherent part of the notion of systematic campaign alleged by Ukraine. Admittedly, Ukraine does not entirely deny that it's necessary to prove this purpose or this intention for its application to succeed. But throughout the proceedings, it insisted that such an intention could quite simply be deduced from its allegation of supposed multiple violations of the Convention by Russia. But this approach on the part of Ukraine is untenable. As we've already underscored, Ukraine's accusation is extremely serious. So in these circumstances, the court's jurisprudence requires that a fully conclusive standard of proof be applied. This standard cannot be met through sheer speculation. It should be noted that not only has Ukraine not succeeded in proving the existence of a campaign, but it hasn't even demonstrated the central element of discrimination, in other words, a difference in treatment that creates the effect of unjustifiable difference. This is a crucial question in all cases of racial discrimination, and even more so in the case of an alleged systematic campaign of racial discrimination. As Russia has demonstrated in its written submissions, a comparability test must be applied in order to establish that the measures denounced by Ukraine show a distinction, exclusion, or restriction or preference based on race, color, descent, or national or ethnic origin, which had a disproportionate effect on the Tatar and Ukrainian communities as compared to other groups. Ukraine seems to acknowledge that it has to demonstrate the existence of a disproportionate impact on the Tatar and Ukrainian communities. However, it does not agree with Russia on 2 points. First of all, methodology, which has to be applied in order to determine that such a disproportionate impact exists. Secondly, the question of seeing whether a differentiation of treatment has to be established. The suggestion according to which it is not necessary to demonstrate differentiated treatment in order to establish the existence of a systematic campaign of racial discrimination is undeniably one of the most surprising arguments put forward by the Ukrainian party. It has to be said that this is an absurd argument in the light of the very clear text of the Convention, which expressly requires differentiation of treatment in the context of the definition of racial discrimination. If Ukraine denies even the most elementary condition of racial discrimination, how can one take seriously its serious accusation against Russia? Madam President, you will find the text of Article 1 of the Convention at tab A2 of your files. Article 1 clearly stipulates that the term racial discrimination refers to any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin. This definition, which includes the notion of differentiated treatment, is at the core of the Convention. The preamble to the Convention also refers to the rule that everyone is entitled to all the rights and freedoms set out therein without distinction of any kind. The Committee for the Elimination of Racial Discrimination also underscored the importance of differentiation. In its general recommendation number 14 that you will find at tab 10.1 of your files, and which you now see on the screen, the committee declared, and I quote, "A distinction is contrary to the Convention if it has either the purpose or the effect of impairing particular rights and freedoms. The committee observes that a differentiation of a treatment will not constitute discrimination if the criteria for such a differentiation, judged against the objectives and purposes of the Convention, are legitimate or fall within the scope of Article 1, Paragraph 4 of the Convention." End of quotation. As to whether or as to the question of knowing how to demonstrate an unjustifiable impact, Ukraine is not challenging that it is an important aspect of the application that is submitted to the court. Russia has shown that the criteria of comparability is at the very heart of the Convention and that statistical data played an important role in the travaux of the committee in serving to establish racial discrimination. The court itself underscored the importance of relying on an appropriate comparator when it declared in Qatar versus United Arab Emirates that the convention, I quote, is clearly not intended to cover every instance of differentiation between persons, but to forbid any attempt to legitimize racial discrimination by invoking the superiority of one social group over another. End of quotation. Notwithstanding this, Ukraine continues to deny that it has any need to produce reliable statistical evidence. In fact, it has produced no statistics which could substantiate its claims. For its part, Russia has produced relevant statistical data in order to assist the court in its mission. As my colleagues will go into further detail subsequently on this, the statistical data demonstrate that the Tatar and Ukrainian communities were not disproportionately affected by the measures adopted by the Russian authorities as compared to other ethnic groups in Russia. In other words, whatever the measure in question, all persons living in Russia are subjected to precisely the same conditions. There's no discriminatory element that affects their adoption and implementation.
Madam President, as concerns the perverted indirect discrimination, Ukraine has presented its claim as if it was based on a case of discrimination with specific intent. And this appears clearly in its pleadings, in which it asserts that Russia had allegedly designed a plan to erase Crimean Tatars and Ukrainian communities in Crimea, and similar allegations were made repeatedly on Tuesday. It is surprising, to say the least, that in its reply, Ukraine attempted to transform its application concerning a campaign of systematic racial discrimination into a claim based on indirect discrimination, and this new approach is in contradiction with Ukraine's initial request that was admitted by the court. And as I said earlier, a systematic campaign of racial discrimination is not an accidental event. It necessarily takes place with a certain intention or for a certain reason, and yet this is precisely what Ukraine now asserts, that a campaign of systematic racial discrimination was somehow conducted inadvertently with no real plan to execute it and escape the attention of the Russian authorities, who should have taken measures to prevent it. This inconsistency is glaring. Ukraine relies on its expert, Professor Friedman, who observes, and I quote, "Indirect discrimination recognizes that equal treatment that has a disproportionate effect on a specific group is, in fact, discriminatory in itself. Indirect discrimination or disparate impact focuses on results, inequality of results rather than inequality of treatment." End of quotation. And this equal treatment does not arise from the definition of racial discrimination provided by the Convention. Racial discrimination relies on a differentiation of treatment, that is to say, a distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin. Contrary to what Ukraine would have you believe, equal treatment cannot therefore constitute racial discrimination. This is also apparent in the preamble of the Convention, whose objective is to guarantee equal rights and equal protection before the law and the enjoyment of the same rights without distinction. Ukraine even demands unequal treatment to obtain equal results, which is exactly the opposite of equal treatment or an ordinary reading of the meaning of equality before the law. But the Convention does not require unequal treatment, even though it does recognize in Article 1.4 the possibility of positive discrimination. Adoption of such measures is not an obligation by state parties, with the exception of the requirements of Article 2.2 that Ukraine does not accuse Russia of having violated. Ukraine refers to the advisory opinion of the Permanent Court of International Justice of 1935 on minority schools in Albania. But this reference is not persuasive for several reasons. First, it is unclear why the 1935 opinion, given in a case on the rights of minorities protected by special treaties, is helpful to interpret the convention that dates back to 1965. And secondly, the Permanent Court did not find that equal treatment constitutes discrimination. On the contrary, the Court expressly declared that equal treatment excludes all forms of discrimination. It's a similar approach as to that taken by the court in the treatment of Polish nationals case. Nothing in the definition of the Convention indicates a notion of discrimination that is different from that of the Permanent Court's definition, that is to say, equality before the law without distinction based on race, which excludes discrimination in any form. In fact, the distinction between prohibition of discrimination by guaranteeing equal treatment and the protection of minorities by adopting special measures in their favor that are not considered as discriminatory is also reflected in the Convention. Indeed, this term figures in Article 1.1 of the Convention, and as Professor Lerner, who is a renowned specialist of the Convention, explains, the purpose refers to the subjective consideration that will define the discriminatory nature of the act, whereas the effect refers to the objective consequences of the law. In other words, different results between ethnic groups in itself does not constitute racial discrimination unless it is a consequence or an objective consequence of distinction, exclusion, restriction, or preference based on race, color, descent, national or ethnic origin. Thus, the concept of indirect discrimination claimed by Ukraine that relies on the assumption that equal treatment can constitute discrimination within the meaning of the Convention simply assumes that such a disparity would in itself constitute racial discrimination. However, this concept neglects the need to establish a cause.
Au plus profond de nous-mêmes. Et aujourd'hui, c'est tout notre